Good evening. This is Rahul Reddy. Reddy Neumann PC is live from Houston, Texas, every Tuesday from 5 p.m. to 6 p.m. Central Time. Emily, what do we have to discuss today?
So we want to talk about what happens if your employer is not willing to sponsor you for the green card. What are your options for self-sponsorship? And also, if you are from the rest of the world, not India, not China, and you're waiting to file your green card, why is it that you should be hurrying up to get that filed right now, given what is going on with the visa bulletin? We also got the news of the proposed fee increase that's been a long time coming, but definitely some important information to know there. And also wanted to talk about the H-1B lottery that's going to be coming up in March. Now that it's January, now is the time to get started on that.
I mean, first thing about the people who are nearing 6 years or probably L1 or whatever visas you are, if you're not getting the sponsorship from your employer, you probably need to think of first thing is that, can I change my employer to join another employer? You have enough time for that. These decisions, if you are in the early stages of L1 or early stages of H1B, that's the time you need to make, not at a later time. Emily is going to discuss more about self-sponsorship green cards. I'm going to discuss, can you actually file a green card application? Can somebody file a green card application if they are not working for the company? Let's say, for example, I am working for Schlumberger, okay? And Schlumberger does not want to file the permanent labor certification. Can I have one other company file a permanent I-140 even though I'm not working for the company, Emily?
Yes, absolutely. This entire process is based on an offer of employment, not actual employment. So as long as the company is willing to offer you a job and you're willing to take that job when you get your green card, you can be working for your current company and have this other company sponsor you for labor certification, I-140, and file the 485 based on
Can I have
job.
two companies? Let's say, for example, I'm working for Schlumberger. Some other company files a green card application. While the process is going on, if Schlumberger wants to file the green card application, will that be a problem?
No issues at all.
So we recommend people to try to pick the company as soon as possible, have them file a green card as soon as possible. Emily, do they really can self-sponsor? Is there self-sponsorship for the green card application?
There are a couple of options for that. National interest waiver, it's an EB2 category, so it doesn't get you into a higher level category, but it can be useful if your employer is not willing to sponsor you. Basically, what it allows is if the work that you will be doing is in the national interest, it allows you to skip the labor certification process and self-petition, file it on your own. You go straight to filing an I-140 yourself, and then once the date is current, you can proceed to that 485. Your other option is the EB1A category for extraordinary ability, which is seeming to be going pretty smoothly these days. We're not seeing a lot of denials in that area. More and more people are filing in that, which we're seeing that in the visa bulletin with EB1 retrogression happening. But that is also an option if you meet those criteria.
This year, more than 55,000 green cards are available in EB1 category, and there already is a backlog for EB1. Though, so historically, we have never seen EB1 getting backlogged, not many times, not especially when there are extra green cards available for EB1. That's surprising to us. So definitely USCIS has been more liberal in approving the EB1As. We have made a separate video about the EB1A, but if you want to consult us, please have your resume before you speak with us, because we want to look at your resume when we discuss. Maybe you should update your LinkedIn. We can see your information on LinkedIn when we speak with you and see what modifications can be done. As Emily has pointed out, that there's also national interest waiver. The only problem with the national interest waiver is it will still be considered to be EB2. It will not be considered as EB1 category. EB1A is extraordinary ability. That's what she was speaking about. Emily, can EB1C, that's where the L1's getting transferred, can they actually self-sponsor?
No, that does require the company to sponsor you. You have to have worked for the company outside the U.S. for 1 year as a manager or executive, and then be offered a position in the U.S. for a related company, also in a manager or executive position.
Can the EB1C guy be eligible for EB1A also?
Yeah, there's there's no restrictions on that at all. If you
So
meet
he's a
any of those
multinational
criteria.
executive manager anyway. So is there a chance that he may even try to fit into EB1A if he qualifies?
Mm-hmm.
Okay. So these things need to be explored, guys, especially when you're 5 years L1B, 7 years L1A, 6 years of H1B is expiring. You need to get those things very fast. That would be in a much better situation for you to act as early as possible, plan as early as possible, so that you can get the things done. Definitely filing a labor and I-140 application is more foolproof method compared to the EB1s or national interest waivers. But if that option is not available, you should definitely look into the national interest waiver and also EB1A. And you need to look into if you're going to qualify for EB1A or probably national interest waiver though. Mostly for the audiences that listen to our things, they will be eligible under EB2 perm labor certification, EB2, EB3 perm labor certification. We don't have any doubt about it. But national interest waiver and EB1A, you should definitely consult a lawyer to see if you fit into that thing. Emily, why the rest of the world has been correct for decades? What's your problem? Why do they have to hurry? Why can't they stay on the H1B or L1, whatever visas for a while?
Yeah, the
TN visas or whatever those e-visas.
The EB2 rest of the world has been historically current, but that's not going to continue because of the higher demand in the EB2 category. We are facing retrogression for EB2 rest of world, and that is expected to continue throughout the rest of this fiscal year, through at least September, if not beyond. And it could even spill down into EB3 to where rest of world is not current. So for people who normally are used to being able to file the 485 as soon as your labor is approved or as soon as you file your I-140, now you may face a waiting period and have to make sure you're timing it correctly. If you're on L1, you have to make sure that you're not going to max out of your L1 time before you're able to file the 485 and get an EAD. Same thing with an E3 or a TN, where you could potentially file that even though you're on a non-immigrant visa that doesn't allow that dual intent. If you time it carefully and don't travel at certain times, don't file an extension at certain times, you could normally still move forward with the green card. But if the 485 is taking longer to be able to file from the time you have the approved I-140, that can create issues for getting continued extensions of the E3 or TN.
So all those people who are in the rest of the world, just guys, the dates are going to move back. You're not going to be as bad as Indian guys will be, Indian people will be, but you're going to get there. You will feel the pain what the Indian people are feeling and the Chinese people are feeling. So if you are, you've been waiting for the green card for a long period of time, please get it out of the way, guys, because you don't know how long it's going to take it. Consult a lawyer, contact your company, look into the alternative methods. If your company is not filing for the green card, probably change the company if you have an option. So please explore those options right now. Don't wait until a long period of time. Oh, what about this lottery fees, Emily? So they're going to propose to increase the lottery fee from $10 to $215. I like it. For a lot of filing fees increases, I don't like it. This one I like it. The reason I feel is that this is going to prevent a lot of fraudulent things. Though I see a lot of the people who have applied lottery with multiple different companies, their H1B is getting revoked because I see some of the companies filing, let's say a batch of 50 people, they found 10 companies and file from each of the company. It's not costing them that much money. Now they're going to increase to $215. At least that may prevent a good number of fraudulent companies to file the H1B. What other fees increases you're contemplating?
Yeah, there are quite a few, and they are pretty major. So the last time we had a fee increase was actually in 2016. They tried to do a fee increase in 2020. They're supposed to be looking at fees every 2 years, but when Trump tried to do it in 2020, he ended up in court, and that was enjoined. So now we've gone from 2016 to 2023 with no fee increase, and they're looking at about a 40% increase weighted average across all the different categories. So some of the important ones to know besides the H-1B registration, for all I-129s and I-140s, so this is pretty much every employment-based category versus non-immigrant versus immigrant. they're adding a $600 fee to cover the cost of the asylum program, which that's kind of never been done before, where they utilize one company's
What does
filings.
asylum has to do with the employment based?
Exactly. So don't know if that will hold up. We'll see how that works out. But in addition to that $600, now they're going to have different filing fees for H-1B versus L-1 versus TN versus E-visas. So H-1s, the base filing fee, not counting the $600, is going to go from $460 to $780. So when you add in the $600 on top of that, you're looking at an increase of $920 for the base filing fee, not counting the extra $500 you have to pay for the fraud fee and the extra $750 or $1,500 that you have to pay for the ACWIA fee. Same
Plus
thing with
$2,000 extra for the people who have more than 50 employees and
$4,000 extra.
Sorry, $4,000 extra. Plus $2,000 for $500 for the filing fees. Oh my goodness.
Premium, yeah. And premium, by the way, they want to, again, they're proposing to switch it from calendar days to business days. So it's going to add an extra week to processing time for premium processing. The L1, that one jumps by $1,200.
This looks like a Nazi time where they're charging the Jews. They don't have any option to go anywhere. So these poor fellows, the companies will end up paying though. That's the eventual thing. And what surprises me in those things, though, the most thing is the C9765, though. We don't have a filing fees for the employment authorization for the people who are filing for the adjustment of status. They started that, and they also started the I-131. We don't have I-131 filing fees, advanced pro filing fees for the people who are filing the adjustment of status. They're definitely from zero onwards, it's proposing. It's increasing. We're going to put a notice in our newsletter. So if you don't subscribe, please subscribe. We want you to write letters because we know what affects you. We will draft it accordingly. We just got this one. We're going to draft it accordingly. We want you to use that because this is not a final thing. It's a proposed thing where you get a chance to speak. You just get a chance to express your opinion. They will take into consideration. And we are going to draft and give it to you. It's not yet done. We're going to give it to you in the next week or so. We want you to write letters to the administration why this fees increase should be or should not be done. We'll give a draft to you by probably in about 2-3 days. We'll get it done.
Yeah, so we do have until March 6th to submit comments on this. And then once everyone submits their comments, they have to review them, decide what the final fee schedule will be, actually publish that final fee schedule, and then it would take effect usually 30 days after it's published. So this isn't something that's changing overnight. I don't expect the H-1B lottery registration fee to change for this year because there's not enough time for them to get through this regulatory process to publish the actual final rule.
Emily, right now there is no lottery system of H-1B. We can't enroll and we can't pay the $10 fees that we have right now. We can't even go there. There is no system. Why are you telling that the people should get ready right now to file the H-1B? Because you can't even open any file. You can't file anything right now.
Yeah, although you can't file anything, it does require a lot of document and information gathering in advance. And so in order to be able to submit everything in this 2-week filing window electronically, we want to make sure that the company has their MyUSCIS account set up. We want to make sure that we have name spelled correctly to match the passport, date of birth correct, country of birth correct. We want to vet your master's degree to make sure it qualifies for the master's cap. So all of those things need to be done before the registration window opens. And if we wait until the first week of March to start gathering documents, everybody is going to be doing it at that time. And it causes a lot of delays and a lot of stress in getting all of that done in time because we are under a very limited filing window for the actual electronic registration process. So we do recommend reaching out to your employer now, make sure they're going to be submitting a registration on your behalf and getting your documents to the attorney so that they can make sure everything's vetted and ready to go when that system opens up in March.
Any other news, Emily? I got some data that you have provided to me. Of course, USCIS provided to us. There are 360,000 people who have approved I-140 approval by September 30th of 2022 that belong to India that have not applied for the adjustment of status. So that's when it go to 360,000 though. In EB2 category and EB3 category, Indians are allowed up to 2,800 each. So that's approximately around 6,000 green cards allowed in EB2 and EB3. Especially if the rest of the world are going to is going to be backlogged though. The maximum they can get is 6,000 green cards in EB2 and EB3. Based on the 360,000 plus the dependents, though, that means a spouse and children. So you're speaking of approximately around 750 to about 800,000 green card people will be waiting from India. Though. So if we take approximately 800,000, and then we have the 6,000 to 600,000 is approximately 100 years. Is it 100?
Yeah.
Yeah, it is 100. So plus there are extra, damn, I can't digest it. It's 100 plus years officially according to them. Yeah, 120 years is what we are estimating this one. Probably this USCIS data is more accurate than the data Emily and I published a couple of years ago, where it said it's 80 years time that it's going to take to get the green card. But there is an institution that contradicted our statement, saying that we are wrong. It's actually 150 years. Since there are 90,000 green cards given last year, luckily for Indian nationals, because the number of extra green cards available, the time got cut down. So it's going to take about 120 years right now to get the green card if you are going to wait. That's the stats that it says, according to the USCIS website right now. Now, that not counting the 190,000 green cards that are pending by the time it is September 30th of 2022, the 190,000, approximately 80,000 at least, I would think so, are Indian nationals pending though. So do the maths, guys. I mean, 760 to about 800,000 divided by 6,000, that's coming about to be 120 years. So plus the amount of people pending. So if you're going to file a green card, why should they file a green card?
Yeah, at this point, for someone in EB2, EB3, it's to be able to get continued H1 extensions.
H1B extension. Yeah, even though it is a long shot for you guys to get the green card, though, you get a lot of side benefits. After 6 years, you can extend the H1B only if you have the green card application in the process. That means if your I-140 is approved or there are some exceptions to it. And your spouse can get a H4 EAD. Those are options available. We still pursue those things. Now, there's one thing though. If the administration stops counting the green card numbers for the spouse and children, the things will move very fast. I mean, that can be current in like 2 to 3 years. At least in 3 years, everything might be current, because the numbers will go up from 140,000 to 300,000 every year. It might not take that much time to clear off all the load at this point of time. So yes, we recommend all the people to write letters to the administration. We have put a link there at the bottom where you can write a letter to the administration, stop counting the family members. So I will discuss later on in the next chapter service going on. The Congress has just changed at 12 o'clock noon Eastern time. Now the Republicans are the majority in the House. We may not expect any good things coming out from the Congress in the next 2 years. So we may want to approach the administration, which can unilaterally change without going to the Congress. The Parliament is called as Congress here. Without going to the Parliament, they can change the thing by interpreting the law a little bit differently than what they were interpreting before. So that's one of the letters that we have created, which we recommend all of you guys to go and write. Anything else, Sunday, before we go to questions?
Yeah, I just wanted to go back to the EB1 retrogression for India. You know, it's kind of somewhat new in the current situation. EB1 has been current for some time. More and more people are filing in EB1, as we talked about with the EB1A extraordinary ability, to be able to get out of the EB2 and EB3 backlog. And normally when EB1 has retrogressed in the past, it usually was towards the end of the fiscal year, meaning in the summer, and then October 1st rolls around and it becomes current again. That happened time and time again. But I want to take everybody back to 2018, because in April 2018, EB1 India backlogged. Guess when it became current?
2021.
April. COVID. The family-based spillover is the only reason EB1 has been current for India for the last 2 years. So I think nowadays, based on that, going forward, we can expect that EB1 India will continue to be retrogress. It's not something that's going to go away in October unless there's a change in how we're counting dependents or a change in the law.
Look at the questions. Surya has this question. For compelling circumstances EAD, does the I-140 has to be from current employer or can it be from the previous employer too? Surya, it can be from the previous employer. Also, absolutely not an issue. You don't need to have a current, the employer that you are going to leave right now. You don't need to have an I-140 with that company, but you must have an I-140, an approval previously with some company.
Sohrab has his parents have their visitor visas, but they're expiring in the next 3 months, and they haven't traveled yet. And he wants to know, is it okay for them to travel now when their visas are expiring? Their passports are valid. So the visa itself just needs to be valid at the time you're entering the U.S. It doesn't have to have a long validity period on it for the stamp. The visa just gets you in the door. Once you're in the door, it's the CBP officer at the port of entry that will decide how long your parents could stay. They could potentially take that into account when they're deciding how long the stay is going to be, but it's okay if they give a longer date on their I-94 and the B1, B2 expires while they're in the U.S. That's fine. They just need it on the day of entry. It has to be valid.
Premnad has this question. I used my EB3 GC EAD for employment. If my EB2 moves, is it possible to refile under EB2? I am not on H1B anymore. No, you cannot refile on EB2. However, you can interfile. You can interfile. Even though you use the GC EAD, you can interfile. There are also ways to resurrect the H1B. By having an H1B, you go into the consulate, getting the stamping and come back. But Premnad, I won't use that method at all. I'm going to just do the interfiling for you. If you were my client, that's what I would do. There is not much difference between interfiling and refiling. I would not like you to get a H1B, go stamping. What happens if you get stuck there? I would not do that. But yeah, interfiling is still allowed after you use the GCAD. Rohit Verma has a question that he wants to travel to Bahamas. He has an advance parole. I don't know the rules of Bahama, Rohit. I for sure know that if you go to Bahamas on advance parole, you come back to USA, you will have no problem none whatsoever at all. But as far as the Bahamas visa is concerned, we don't know what that particular country's rules are.
And Jesh says, I have an H-1B approval for consular processing from company A, is in the U.S., wants to change jobs to company B without activating that other company's H-1B approval, and wants to know if he can later activate the H-1B by filing with company B. There's a good chance that USCIS will say, no, you have not been counted in the cap and have to go through the lottery again. So what the rule is once you have an I-129 petition approved, you're only counted in the cap if you've actually been granted H-1B status, meaning you have an I-94 for your H-1B status, or you have received the visa by going for stamping at the consulate. So if you have not gotten the stamp, that means you cannot transfer that H-1B to another company. USCIS very well might say that you have to go through the lottery because you haven't actually been counted in the cap yet.
Question from Priyank0329 from YouTube. I've received an EAD approval in AP. My priority date is February 2013 in EB2. Is it possible for filing an I-140 in EB3 as the dates are moving faster? Yeah, absolutely, you can. Here is the thing though. If you contemplate, even if the final action dates are not current, if you are contemplating EB3 is going to move forward, file an EB3 I-140 approval, you don't have to use it. When the dates become current, you can use it at that point of time. Is it going to cause any problem by filing using the same I-140, same labor certification for filing an EB-3? Absolutely no problem. You can have two I-140s with the same labor certification. No problem with it. You don't want to use EB-3? That's fine. You don't have to. If you want to use it, you can. So for those people, especially who filed in EB-2 and they don't have an EB-3 I-140 approval, if I were them, I would spend that extra money in getting the I-140 approval in EB-3 and have it ready. Can employees spend the money to get the EB-3 approval? Yes, it's legal to do so. If your employer allows you to do so, you can spend the money in getting the EB-3 approval and make it ready.
Let's see here. Sairam joined company B after his perm was filed by company A, and it's still pending with company A. And he wants to know if he can go back to company A and take advantage of that perm, and what are the implications of that. So assuming company A did not withdraw the pending perm, if they're willing to take you back and continue the process, you can absolutely do that. No issues at all. As long as they're taking you back with the same job offer. It doesn't have to be the current job, but the job they're offering you when you get your green card based on your perm needs to be the same as what they're willing to offer you now. But other than that, no issues at all with going back to the same company.
Ankit has this question. Can the employee pay for the H-1B extension after the I-140 is approved? The employer has reservation. No. The employee cannot pay the legal fees, cannot pay the filing fees. Under limited circumstances, of course, they can pay the premium processing fees. They can pay for the H-4 legal fees, they can pay for the H-4 filing fees, but they cannot pay legal fees or the filing fees of the H-1B. Similar question comes from Dr. Krishna Reddy. How much is the total fees for the lawyer's fees for a fresh H-1B from fresh H-1B from Canada? Well, first of all, the employees cannot pay the fees. And if you have an employer who is willing to give you a job and they're willing to pay, I would recommend that they should contact a lawyer. That's a better way of approaching a lawyer instead of you telling, oh, tell me the fees. Well, it will be depending on the company. So the company you need to contact.
Amit has a question on the H4 EAD auto extension. In this situation, as of now, the H4 and the H4 EAD have both already expired, but the H4 EAD application was timely filed before it expired. And now the H4 extension has been approved. The EAD is still pending. So can you now get the auto extension even though at the time of the expiration of the H4 you weren't eligible for it? Yes. So you could go back to work now based on the fact that you got that H4 extension approved. All it requires is a pending 765 that was filed before the current EAD expires in the same category, and an H4 I-94 that extends beyond the current validity period. So even if you got that I-94 later on that H4 extension approval notice, you still can qualify for the auto extension now.
Rakesh Patti has this question. My company is closing our Minneapolis location office. His I-140 is approved. Does he need to file a permanent I-140 again? If the I-140 location has been listed as Minneapolis, they are going to have no operations, none whatsoever at all in Minneapolis. You may need to file the permanent I-140 if you want to eventually get the green card through that.
Prem says, my H-1B transfer has been approved, but the H-4 extension is in process. The current H-1 and H-4 are valid still till April 2023, so they have not expired yet, and wants to know if they can travel to Mexico and use automatic revalidation to get the extended I-94. Yes, we have had many people do that. So as long as you're traveling to Mexico before your spouse's current H-4 expires, even though the H-4 extension is pending based on your transfer, you can show your transfer approval notice at the port of entry, and they are giving the spouse that extended H-4 I-94 till the date of your new approval notice, so that she can qualify and get the EAD filed and do the auto EAD extension.
Sai is asking the question, can I downgrade to EB3? his final action date is current in EB3, but in EB2, the current is only filing dates. Yes, you can, absolutely not a problem. If I were you, I would file the I-140 and I will convert it to premium processing if I were you. You can, it's not going to cause any problem.
Jitesh has the EB1C I-140 approved with a March 2022 priority date and wants to know when that final action date might be current. With right now it's back to February 2022, but the filing date chart is June 2022. That suggests that EB1 date, final action date, may take until October just to get to June, which would be current for you. So hopefully by October, but definitely no guarantees just based on the number of people that are filing in EB1.
Mr. Gangadhar has this question. He has filed I-140 and 485 application together in EB1C in December of 2022. His son is 20 years old. Is he safe? He's speaking about Child Service Protection Act. Or is he going to age out when he becomes 21? Here is one of the problems, though. There has to be 4 things that has to happen concurrently at the same time for your child to be protected under the Child Service Protection Act. The first thing is that the I-140 must be approved. In your case, you said it's been filed in December. So I'm assuming that I-140 is not approved in December. In which case, though, then he is not eligible under Child Service Protection Act at this point of time. At a later date, when the I-140 is approved, if the final action date is current at that point of time, then he becomes eligible. Now, I will tell you all 4 things have to happen in the same month. It cannot be in a different month. There has to be. One, the I-140 must have already been approved. The final action date has to be current. The child has to be under 21 under the CSPA. You must have filed the 485 application. You meet all 3 requirements in December of 2022, but you don't meet the 4th requirement, which is the I-140 must have been approved. So he is still not protected under CSPA, Child Service Protection Act. You may want to contact a lawyer where we may suggest you to actually not do the premium processing at all when the premium processing is eligible for you, unless the final action date is current. It's better to consult a lawyer to plan it properly, though, because he's not protected right now. There are ways to protect. Maybe at a later date he will become. Because the time period your I-140 is pending will be deducted from your son's age, though. So he's not going to become 21 according to the immigration law for the purpose of the green card when he becomes 21. He becomes 21 at a later time, which will be based on the I-140 approval, though, on what time the I-140 took. Why do they make it so complex? Well, I guess they want to feed the immigration lawyers. Why can't they put 1 year or 2 years? Well, they make it very complex because I guess they want to feed immigration lawyers. But it is better that in this particular case, you consult a lawyer, go through it, have the maths ready, and see when he will be eligible. You may want to transfer him also to the F1 visa to be on a safer side. Even though you file the 485 application, the child can convert into F1 visa. What happens if later on, if the child is protected in the CSPA, can he still get the green card? Yeah, even though if it's an F1 visa, he can still get the green card. So you may want to consult for all these reasons a good immigration lawyer.
Nishant was previously on an H-1B from 2017 to 2019. This was a change of status from an F-1 in the past. Now he's in Canada and soon to be a Canadian citizen and wants to know if he can get the remaining 4 years of H-1B if he gets a new sponsor. And he heard that Canadians can go directly to the port of entry with the approval notice. Is that true? Yeah, so you have the option, since you've been outside the US for 1 year, of either going through the lottery and getting a fresh 6 years if you're selected, or avoiding the lottery and getting the remaining 4 years that you have left by showing that you were previously counted in the cap back in 2017. So that can be filed at any time. And you're right, once that is approved, once you're a Canadian citizen, you're not required to obtain a visa stamp in your passport. Canadian citizens are visa exempt. So you can just take that approval notice and go directly to the port of entry, and they will issue you an I-94 for that H-1B status.
Dr. Krishna Reddy, Krishna Kode has this question. If I upgrade to the H-1 premium processing, though, will they approve the H-4 and EAD at the same time? The answer is simple, one-word answer is no, they won't. However, though, we are noticing that a significant amount, a good number of amount of the H-4 and EADs are adjudicated at a similar time as the H-1B premium processing. So definitely if you have something pending though, I would get the premium processing because at least you have a chance of getting the H-4 and EAD approved within that point of time.
Elvis says, I was added as a derivative to my spouse's EB2 green card, and the spouse got the green card, but this one was retrogressed, now divorced, and on a separate H-1B, but wants to know, can I use that priority date for my own? It's a great question, but unfortunately, no. That priority date can only be used by you if you are filing as a derivative of your spouse's application. If you're filing the green card on your own, you can't use your spouse's priority date. Even though you filed the 485, you have to get a new priority date based on when your employer files the labor certification for you.
Question from Venkatchala from Facebook. He's an H-1B, he bought a new home, he moved into that home. Can I rent the previous home and get the rental income? Will that cause any problem for my H-1B or GC? No, no problem for you. Absolutely no problem for you. Now, if it's just one house that you are going to rent, we don't. But what if somebody wants to rent like 7 homes or 10 homes? Is that going to be a problem? Yes, because that becomes a full-time employment at that point of time. But for a single home to rent for you and to take care of any of those things, we do not see any problem whatsoever at all for you. What is the cost of filing a EB1 investment? First of all, EB1 is not investment, though. There's no EB1 investment. There's only EB5 investment. EB1 is extraordinary outstanding researcher or multinational executive position, though. So EB1 filing, we need to discuss with you if you are eligible for it, though. Not many people will be eligible for EB1 application, though. So we want to judge to see, if somebody has an Oscar award or Nobel Prize award, and then they come to us and say, Rahul, can you file a EB1 green card for me? Yeah, what is the fees? Well, we'll cut down the fees. We just have to provide them Oscar awards, right? I mean, I don't have to explain them anything to the USCIS. Believe me, guys, they're going to approve it. Let's say the guy comes with the Nobel Prize and say, Rahul, can I get you green card? I just will present that. This guy got the Nobel Prize. That's it. I won't even present anything else. So the fees for that guy will be different. What if somebody has less publications, less things? If they have a lot of publications, things will be different. So it depends on how hard we have to work on it. For a Nobel Prize one guy, I won't work anything. I would just put it on and then get an approval. But for different people, there's a lot of work involved. We have to give you this sample recommendation letters. We have to evaluate the recommendation letter. We have to look into your profile to see if there is any changes that you can make, any publications are there, or if any of the other people who have used your publications, they have benefited from those, can we get those articles? So there's a lot of work that will be involved in it. We can't just give the fees online saying a blanket fees to people, guys. That's not good to, it's very hard to give for us.
Mahesh says, after receiving the green card, is there a minimum time we should stick to the current employer? No, there is no minimum amount of time. You're not required to stay with that employer for any specific length of time. If you've probably heard a rumor about a 6-month rule, there is no such thing. There's no rule requiring you to stay with an employer for any length of time after receiving the green card.
Mohan Singh has this question. Any update on Eagle Act? Eagle Act is dead. Dead. The way it works in the Congress, or Parliament, they call Congress here, is, let's say, for example, we have to make it 300 steps to climb up a mountain. And we climbed 299 steps. And the day gets over. Guess what? We got to start all the way from zero again. Now, unfortunately, that's going to be the case for us to get any of that Eagle Act kind of thing again. All the efforts that were being done gone. That's the reason where we put a lot of emphasis on the last 1 month to put a stress on the Eagle Act, but it did not, they did not even dare to put it for voting because they didn't thought they were going to win it. If you recall, about 2 years ago, that was in 2021, 2020 December. At that point of time, it got passed in the House, it passed in the Senate, but it was not passed exactly. So we were at 298 steps instead of 300 steps. We got beaten. Then what happened? We got to climb the whole step from zero to all the way. This time we only came up to about 150 or 160. We did not come up to 200 guys at this point of time. So now we are back again from zero, and we have a Republican House right now, which may be very reluctant to take, at least at this point of time. Things change, guys. I mean, things change. It was the Republican Congress that actually passed the removal of the per country limit back in when Trump was there. So at this point of time, we don't see any hope. I would say that probably next year, that means that in 2024, we can see some signs of the bill moving if it is going to move. But for now, Eagle Act is dead. We want all the people to put the efforts on the administration rather than the Parliament or Congress. So please write letters that we are putting right now of not counting the family members. That is a better way on.
Ramsey has entered on AP recently and has the EAD that's valid till 2024, but the stamp on his passport says paroled until December 30th, 2023. What does this mean? Yeah, so when you're entering on AP, your end date on the I-94 and the stamp in your passport is not related to the end date of your EAD or AP. They just give a 1-year entry, and you're admitted as a parolee by getting advanced parole. So you're basically, when you get an advanced parole, you've gotten advance permission to be let back into the country after you left without abandoning your 485, and they give you that I-94 for 1 year, but that doesn't mean that you're stopping being lawfully present after 1 year. As long as your 485 is still pending at the 1-year mark, you can continue to stay in the U.S. based on that. Or if you get your green card by then, now you're a green card holder, you don't need an I-94 anymore.
Sahul Amidas' question, would it be a problem if I got multiple promotion? The job description only slightly changed. No, I don't see any problem in the GC interview. Job description, especially when the priority date is stuck in 2011 to 2023, guys, it's going to change. Nothing remains the same for 12 years, okay? It's not going to be the same. It will change. So we do not expect, but it's better to articulate it to them properly though. Is a job description, are you doing a completely different job? Yes, I am doing completely different job. No connection at all. Then definitely the USCIS official will get curious though. But if it's a software profession, we consider all software professions to be the same. So you're fine. If you move from Java, J-A-V-A, software to SAP, for us, it's still the same software. So you're fine in those particular things. Question from Nanda. Can we use the previous employer's I-140 to renew the H-4 EAD? I have a visa validity until 2024. Absolutely you can. If the I-140 has not been withdrawn for a period of 180 days, you can use company A's I-140 to extend the EAD while your husband is working with while your spouse is working with company B. You can do it with company C, company D, company Z, all along, no problem at all.
Arun has a priority date in 2012, received the EAD and AP for him and his wife. His wife already has the H-4 EAD expiring this May and wants to know if she can keep working using her GC EAD by not filing the H-4 EAD renewal. Yes, so once that H-4 EAD expires, she can just automatically switch over to the GC EAD. I'm assuming that your I-140 is approved and no issues, red flags in your 485 that might create an issue. So if it's a relatively normal employment-based 485 where your I-140 is approved and there's not a lot that can go wrong, It is safe to rely on the EAD and just be in the US based on your adjustment of status and forego the H-4 status.
Sri has this question. He has received a GC in EB1B category 2 months ago. Congrats, Sri. I'm considering leaving the employer. Will it affect the green card? No, it will not. I mean, there are people cite so many articles saying that they pay the consultation fees and cite. No. It's only your intention to work. You can change your intention. Remember, on January 1st, you made all those resolutions. We will see after 1 week what you're going to do about it. We'll see if you're going to run 3 miles a day morning, 3 miles a day in the evening, every single day for 365 days. Remember, you made the provision? We'll see after 1 week whether you do it. If you don't, in the same fashion, you had an intention to work in that particular profession. Now you change your intention. What can you do right now? Can you flip a burger in McDonald's? Yeah. Can you be an Uber driver? Yes. Can you be Microsoft CEO? Yes. Will that cause any problem in getting citizenship? No. Will that cause any problem in revoking your green card? Absolutely cannot happen.
Kamlesh's wife's I-94 is expiring January 9th. Already filed for the EAD, the H-4, and the H-1 extension back in December and wants to know if she gets the automatic 540-day extension of the EAD. She's expecting a job offer soon. Unfortunately, no. So just filing the H-1, H-4, and H-4 EAD renewal on time does not give her the automatic extension. The only thing that does that is if she gets the H-4 I-94 that extends beyond January 9th, 2023. Then she gets the automatic extension. So if your H-1 is not filed in premium, you may want to upgrade it to premium. And then you could potentially get that approval, have her travel and come back in before January 9th to get that extended I-94 using automatic revalidation. We have a whole video on that. Or we are seeing from time to time with an H-1 premium approval, sometimes the H-4 and H-4 EAD are getting approved all together again. They're kind of recoupling that. So it's possible she may get the H-4 extension approval when you get your H-1 extension approval and get the auto extension that way. But she has to have I-94 valid beyond January 9th to get the auto extension.
Rangesh from YouTube has this question. Can we do the transfer of underlying basis letter between EB2 to EB3 multiple times when the priority date keeps changing? Yes, you can. However, though, Rangesh, I would recommend not just write the transfer of underlying basis letter, but also submit the 485J supplement. That's going to be more effective. We thought that transfer of underlying basis, just a letter would be enough, but USCIS came up with this I-485J for doing that transfer of underlying basis, which they did not officially tell us to do that thing, but they started telling it. Yeah, there's nothing wrong in using the transfer of underlying basis multiple times. Nothing wrong with it.
Sunil is on H-1B and wants to know if you can use the marketplace insurance plan the government subsidized. Will that impact the perm processing or the green card? So assuming you're talking about like healthcare.gov, that is not something that is considered to be under the public charge rule. Very specific, the types of benefits that you have to get in order to be subject to the public charge rule. And pretty much anyone who's on H-1B is not eligible to get any of those benefits anyways. So there is a recent article on rnlawgroup.com about the new public charge rule because it did take effect just last month. And it sets out exactly what is a public benefit that would disqualify you potentially from receiving the green card. Again, most H-1B holders are not eligible for any of those public benefits. So it's very unlikely that the public charge rule is going to come up.
My GC is approved, but it's not in hand. Can I use the I-9 for e-verification and later on use the GC before starting the job? Yeah, absolutely you can. Because technically speaking about for I-9 verification, they need the green card though. The USCIS does tell us that you can't base the online information to accept the jobs. You can't do that thing. So technically, your EAD is still valid. You don't have a GC with you. We don't see any problem in that. We don't don't see any fraud. We don't see any problem with that. Can I get a B1, B2 if I have an approved I-140 with the previous employer and the priority date is not current? This question comes from RV. You may be able to, but you need to articulate to them that why you are visiting. For the purpose, the reason is that for visiting visa, you must have intention to temporarily come into United States, not to permanently come into United States. But there is an application called I-140 that says, oh, I want to be in USA forever for good on a green card. So how do we satisfy the CBP officials, the State Department? You can tell them, look, I do have an intention to permanently go to United States. But at this point of time, when I am visiting United States, my intention only to go visit, do the visiting activity and come back, and eventually I want to get the green card. You can do so. This happens mostly with the family-based immigration guys, where brothers and sisters, they file a green card, but now the brother wants to come and visit the United States. They can, but one thing is that you have to convince the officer, and not only that, in the DS-160 form, they will ask a question. Have you ever filed any immigration petition? You need to answer yes to that question. If you answer no to that question, that will be a misrepresentation. Yes, you can do that, and you can actually come into the United States. We have seen time and time again, if you are very honest to the consular officer, you are very frank with them, they tend to approve the B1, B2s much better, even though you have an I-140 approval.
Vivek is an Indian national, has the EB1 priority date of September 2022. I-140 is approved, 485 is pending, and wants to know if you can expect the final action date to move to September 2022 by the end of this fiscal year. Well, based on the filing date chart, which gives us a prediction of where the final action date should be by the end of this fiscal year, that's at June 2022. So that would suggest no. That it's not likely to move to September 2022 by September 2023. It may be next year before that date becomes current.
EB1C, it's been 120 days that the I-140 has been responded. Is there a point of concern? I would recommend just file a premium processing. If you're eligible for, there are certain rules for you're eligible for. Looks like you may be eligible for premium processing. So I would definitely, if you're eligible for it, go for it. It's a wrong presumption that if you file a premium processing, you tend to get more RFEs, you tend to get more denials. We do not believe in that. You will get the RFEs and the denials or approvals faster. That's all it is, just faster. Premium processing gets faster. It doesn't increase or reduces it.
Kashuti wants to know, my prevailing wage came back and we're starting the next step. I'm currently an individual contributor as a product manager, due for a promotion next month to a senior product manager. Do I need to start over? This very much is going to depend on the lawyer that's handling your case. We would generally not start that process over, assuming that your job duties remain basically the same and it's just a simple promotion. If the job duties changed materially to where maybe a different occupation category fits or is a different wage level, that may be a different story. But a lot of times our clients say, yes, it's a promotion, but the job duties are exactly the same. That does not impact the prevailing wage and the process can continue. But many attorneys out there say, nope, we have to start the whole thing over again if there's any little change in your job compared to what's in the prevailing wage. I don't agree with that. I've not had any trouble with proceeding with the perm or with an I-140 when there's a change like that. But some attorneys go the other way with that.
A lot of the big companies, lawyers, Emily particularly, Microsoft, Apple, Google, they're also in the same agreement with us, though. It's only some bad lawyers. Always, if there's one bad person, the whole name comes out. All lawyers are bad. But most of the large companies also probably, they will agree with us 99% of the time.
Ronnie says the 45 is pending and the EAD and AP is approved. Now that office location has closed and will be working from home, do I need to redo the perm or I-140? Well, assuming the 485 has been pending for 180 days, you're eligible to use AC-21, which allows you to move that green card process to a new employer. It also allows you to move the work location of the existing employer. So as long as the job remains similar to what you were originally sponsored for, you can move that job to a work from home situation without having to redo the process.
Question that is asked is, that is Fareeq Karar. Can we apply H4 and EAD extension electronically? No, no, no. Here is the reason though. If you file electronically, you cannot club those two applications together. That your EAD might take a long period of time to get it approved though. So that's the reason I would apply for H4 and EAD together rather than separately.
Yeah, and on that, with this new fee proposal, they're actually proposing different fees for I-539s if you file on paper versus filing online. Cheaper to file online. And the same thing with the I-765. They want to offer it at a lower fee in order to file that online. The problem is if you're filing an H1, H4, and H4 EAD, and you want to file the H1 on paper because that's your only option, how is it that you're going to file your H4 and EAD online? You can't use an attorney right now to file online, so you have to file on your own, and now they're going to be processed separately. There's no coupling of those applications to get them approved together. So I'm not sure what USCIS is trying to do by giving a discount for filing online. But for most people, it's not going to be beneficial because you have to file it with the main applicant that has to be a paper filing.
Well, Emily, that's the reason I tell the USCIS is from Mars and the State Department is from Venus. Anything else, Emily?
I think we are out of time for today. Thanks so much for joining us. As always, we'll be back next Tuesday at 5 o'clock Central Time. And in the meantime, you can join one of our daily conference calls if you have additional questions by going to rnlawgroup.com to get that schedule.
Thank you very much.